Ryan Cremines presiding. All those having business before the court draw near and you shall be heard. God bless the great state of Ohio and this honorable court. You may be seated.
All right, morning, everybody. Go ahead and have a seat. Review hearings, arraignment.
All right. Today is the morning docket of the Lawrence County Municipal Court. I'm acting Judge Ryan Cremines. Today's date's June 10th, 2024. First cases we're going to call are the review hearings. So once you hear your name, come up to this table on this side of the room, and we'll go through that process.
Heather Blevins, Naaman Cox, Eddie Eastep, Brian J. Finley, Olivia L. Hilton, Tyler M. Kemper Jr., Chase L. Lewis, Micah Mayo, Zachary Russell. All right. Ms. Blevins, this is State of Ohio versus Heather Blevins, case number CRB 23158. Ms. Blevins is present in court today for review. Ms. Blevins, it looks like you still have 30 hours of community service to do, but it looks like you've paid a pretty good amount on your fine throughout this matter. Do you have a payment today?
I can make one online.
Okay, how much are you planning on paying?
Maybe 50.
Maybe 50? Okay. Are you working currently?
Yes.
What days of the week do you work?
It rotates. I'm a paramedic. I work 24-hour shifts.
Your Honor, if I may, she just turned in 31 hours of community service. That it will be acceptable.
Okay. That should include your community service hours. Any hours that you work on community service going forward, you get credit towards that off your fine. So if you want to aim for costs, if you want to work off some of that time, you're welcome to. It'll save you $50 a day. All right, I'm going to give you another review date. We have to do it.
Yes, to the next, well. Usually just gives Monday or Friday, whatever's good for you. Stay away from trial days.
You've done very well. I'm going to go out a ways on this. Let's do September 16th at 9 a.m. If you have everything done by the paid off or done by then, you will need to return.
Okay. Thank you.
Naaman Cox. All right, this is State of Ohio versus Naaman C. Cox, CRB 23569, TRC 221663, ABCD&E, TRC 213062, ABNC, and TRC 211917, A and B, and CRA 21500. Mr. Cox, you still have a decent amount to do. Are you still with Bethesda?
I completed the program. I've been trying to follow up on some community service. I haven't done any recently. I do plan on paying some of my fines today.
Okay, are you working currently?
Yes.
Where are you working at?
I do logging. I'd cut timber.
Okay, what days of the week do you typically work?
I can fluctuate my schedule to whatever you need me to do.
Okay, we need community service workers on Tuesdays and Thursdays, and it looks like one case you still have 60 hours
Yes.
of community service left.
I have some local community service that I can do. He's aware of one of the places that I work at. It's really convenient for me to stick with what I've been doing, if that's okay with you.
That would be up between you and Mr. Cooper. I'm going to give you a new review date, but I'm not going to go out quite as far. Let's go to July 22nd.
22nd?
Yes,
Okay.
for review. Okay.
Thank you.
Thank you. Eddie Eastep. Eddie Eastep.
Did not check in, Your Honor.
Thank you, Mr. Major. Time is now 9:51. Mr. Eastep is citing a report for 9 a.m.
Excuse me, Your Honor. He just called and they're running traffic. They'll be here shortly.
Okay, we'll recall this later in the docket then. Very Olivia Gilpin. All right, Ms. Gilpin, please step forward. This is case number TRC 23-1291 A and B, CRB 23-591, State of Ohio versus Olivia L. Gilpin. Matter set for review.
Your Honor, she has turned in some community service. I will have to call and verify this.
Okay. Looks like on one case there was 18 hours left. There was 18 hours left on one case, and in one case there is $210 remaining, and the other case there is $535 remaining.
Your Honor, she's compliant with all services at Bethesda. She's an outpatient still.
Okay. Ms. Gilpin, are you working currently?
No, I thought I had a job a couple of days ago, but where I have a violent felony, they don't hire a violent felon, so.
Okay, what I'm going to do then, if I were to order her to do community service in the next couple of weeks during the week, would that be a problem?
She's an outpatient. We have groups in the morning, afternoon, and evening.
Okay, I wanted to make sure it wasn't interfering with
Yes.
treatment. All right, Ms. Gilpin, I'm going to order you to do community service this week on Tuesday and Thursday.
Okay.
We need some workers, and that'll help take care of some of your community service hours. I'm going to set you another pre-trial a review hearing. For July 26th.
July 26th.
Yes, ma'am.
Thank you so much, Your Honor.
Thank you. Tyler M. Kemper Jr. This is State of Ohio versus Tyler M. Kemper Jr. CRB 23630. This matter is set for review today. All right. Mr. Kemper, that's an excellent report that you've received from your treatment provider.
Your Honor, in addition to that, he has also already obtained his GED while he's been in services with us. So he has been doing exceptionally well in our program thus far.
Great. Looks like we still have a little community service left, but I'm a little, and some fines to pay, but I'm a little more concerned with you making sure that you're doing well in treatment. I'm going to set you as well back on July 26th for review, 9 a.m.
Thank you, sir.
Thank you, Your Honor.
Thank you. Chase Lewis. This is CRA 141065, State of Ohio versus Chase L. Lewis. Set for review this morning. Mr. Lewis, you've done very well. You're down to $518.82 owed. You can, if you got time and you want to work some of that off, again, we need community service workers.
I don't think I can. I think it's restitution.
Okay. Yeah, you're down to $518.82, so all your community service is done. You got a payment today?
I made a payment online for $30.
Okay, perfect. I'll set you back for July 26th for review. If it's all paid off, you won't need to appear.
Okay, thank you.
Thank you. Zachary Russell.
Yes, sir.
All right, this is State of Ohio versus Zachary Russell, CRB 2498. Mr. Russell is present for review.
Your Honor, if I may, he was here Saturday for community service, it may not be up in this closing.
Okay.
Yeah, I also made a payment online this morning.
Okay, how much did you pay?
40.
40. You'll have 24 hours of community service left once that posts.
Yes, sir.
And then $200 remaining on your fine. You working, Mr. Russell?
Yes, sir. I work at Hoser Hospital in Gallipolis Monday through Saturday.
Okay, great. All right, I'll set you another review hearing. I'm gonna go out a little further. Let's do September 16th. 9 a.m. for review.
Thanks, sir.
Thank you, Mr. Russell. We got Micah Mayo from Zoom. All right, Mr. Mayo, this is CRB 23-460, TRC 23-1042, State of Ohio versus Micah Mayo. Mr. Mayo is appearing via Zoom. And Mr. Mayo, I don't have any notes that you've done anything on your case.
Yes, sir. I had paperwork with me today that I've done some community service. I'm almost done with it. I've been doing it at Mills and Wells on the west side of Columbus. So,
Okay, hadn't been turned in yet.
no, I know, yeah. I had car troubles today.
Okay. Do you have any money to pay on your fine?
I can never pay no more today. Yes, sir.
Okay, how much you planning on paying?
I can pay 50 today.
50 today? Okay, I'll note that, you're gonna make that payment. And I'm going to set you another review hearing for July 26th.
Okay.
You need to get that community service turned into probation so that we can update the file.
Yes, sir.
All right. Thank you, Mr. Mayo, and we'll see you July 26th at 9 a.m.
Yes, sir.
Thank you. Okay. The next group of cases we're going to call are the arraignments. When you hear your name called, come up to the same desk, and I'm going to go through your rights before the court. So you have the right to remain silent. Everything in here is being recorded. And so if you say something that is against your interest, it can be used against you. You have the right to an attorney. If you can't afford an attorney, the court can consider you for court-appointed counsel in this matter. You have the right to reasonable bail, and you have the right to have your charge or charges heard by the court or by a jury, and for the state to have to prove each and every charge beyond element of the charge beyond a reasonable doubt. When you come up, I'm going to ask you for a plea. You can either enter a guilty plea, not guilty plea, or no contest. Guilty plea means you're admitting the facts and circumstances, and that's the plea you're entering. If you enter a not guilty plea, you are denying the facts and circumstances at this time. If you enter a no contest plea, it means you're not admitting the facts, but you're indicating that you're not contesting the case either. And then if I think the state would have enough evidence, then I could find you guilty. If you are unsure of what you should do, you should enter a not guilty plea as it preserves all of your rights. Call first arraignment.
State of Ohio versus Jacob R. Nichols, case number TRC 24-1236, A and B.
This is State of Ohio versus Jacob R. Nichols, TRC 24-1236, A and B. Mr. Nichols is present before the court. Mr. Nichols, it's alleged that on or about June 7th, 2024, in Union Township, you were operating a motor vehicle while under the influence of alcohol or drugs abuse. It's a violation of Ohio Revised Code 4511-19A1A. It's a first-degree misdemeanor. Maximum penalty 180 days in jail. Minimum penalty either 3 days in jail or 3 days in a driver intervention program. Maximum penalty is a $1,075 fine. A license suspension from 6 months to 3 years. You're also cited for failure to control. That is a minor misdemeanor. violation of Ohio Revised Code 4511.202, maximum penalty $150 fine and court costs. How do you wish to plead?
Not guilty, Your Honor.
Okay, I'll accept your not guilty plea. Are you working?
I am.
Do you wish to be considered for court-appointed counsel?
Yes, sir.
All right. How are you paid typically?
I'm sorry?
I've got to assess your income to make sure you qualify. How are you paid?
How am I paid? By hour?
Okay, you're hourly?
Yes.
40 hours a week?
Yes, sir.
What do you make per hour?
18.
Okay. Do you have any dependents?
No, sir.
Okay. You will not qualify for court-appointed counsel, but you make too much money presently. So if you want an attorney, you'll have to hire your own. I will let you sign a $1,000 signature bond if you want to. Form's right there. And we'll have a come back for pre-trial on June 24th, 10 a.m.
Thank you, Your Honor.
Thank you, Mr. Reynolds.
State of Ohio versus Matthew Kern, case number CRB 24360.
The State of Ohio versus Matthew Kern, CRB 24360. Mr. Kern is present and is being handed a copy of the charges presently. Mr. Kern, it's alleged that on or about June 10th in Fayette Township, you did while voluntarily intoxicated in a public place or presence of two or more persons, engage in conduct likely to be offensive or cause inconvenience, annoyance, or alarm, persons of ordinary sensibilities, which the conduct, if the offender were not intoxicated, should know is likely to have that effect on others. That's a violation of Ohio Revised Code 291711B. That is disorderly conduct and minor misdemeanor. How do you wish to plead?
Not guilty.
All right. I will accept your not guilty plea. It looks like you've already bonded out with Sowers. This is a minor misdemeanor, so your liberty is not in jeopardy, so you're not entitled to court-appointed counsel. However, if you do wish to seek counsel, you certainly are entitled to do so if you wish to hire counsel. We have to have your trial within 30 days, so we'll set this for a trial. June 21st.
What time?
Noon. We'll see you back June 21st at noon.
Thank you.
Thank you.
State of Ohio versus Antonia Caldwell, case number TRD 24643, A and B.
The State of Ohio versus Antonia B. Caldwell, TRD 24643, A and B. And it looks like, Mr. Caldwell, you failed to appear for a pretrial on May the 10th.
Yeah, I got my court dates confused in Kentucky and I missed this one. I tried to come back like twice already.
Okay. We'll recall the warrant. And I'm going to set you on traffic docket.
Okay.
June 25th at 4 p.m.
June 25th. All right. Thank you.
Is it for Susan?
Be it as a pretrial. Hasn't been a plea yet.
We're ready to go to the Lawrence County Jail, Your Honor. State of Ohio versus Heather Prager. Case number CRB 24104, CRB 19742. You know, we may not be able to do this right, so Mr. Morphy's here.
Mr. Morford here. Yes. The State of Ohio versus Heather Prager, CRB 24104, CRB 19742. It is set for a pretrial and a review today. Ms. Prager is in the Lawrence County Jail appearing via Zoom. Her attorney, Mr. Morford, is now in the courtroom. Mr. Morford, this is Heather Prager. It's set for there was a failure to appear on April 15th. For that pretrial bench warrant was issued. She is presently incarcerated in the jail. And there was an old review that it doesn't look like from 2019 that anything was done on it.
Your Honor, she was also at Bethesda and Marina.
Okay. Do you want time to reach out down there, Mr. Morford?
If you don't mind, Judge, could I have the file and let me call her?
Absolutely. We'll recall this later in the docket.
Thank you, Your Honor.
State of Ohio versus Joseph Cunningham. Case number CRB 14489. And Donald Denny is on deck.
This is State of Ohio versus Joseph Cunningham, CRB 14489. And there's a failure to appear. Looks like May 10th for failure to appear for review. All right, Mr. Cunningham, can you hear me? All right. Do you admit or deny that you failed to appear for your review hearing?
I did.
All right. How many days have you been in jail?
I did pick up last night.
All right. So you spent a night?
Yep.
Okay. It doesn't look like you've done anything on this case. This is a 2014 case, and you've done, well, you owe $597 and you've paid nothing. Is there a reason you've done nothing?
No, I currently lost my job, and I just realized I had to see a couple months ago whenever I came in there in the courtroom. I didn't know nothing about it. They sent me the STAR program for felony and didn't take care of this.
Okay. You're not working currently?
No.
Okay. I'm going to go ahead and appoint you counsel on this. I'd appoint Mr. Steyer. Looks like he was originally appointed and has been involved in this case.
Okay.
Mr. Steyer, this is Joseph Cunningham. You had him at one point in the past. He had failed to appear. It's a 2014 case that he's been sentenced on. There's been nothing done on this case. And don't know if you want to speak to him before we go any further.
Your Honor, give me 1 second here. Is he set for Friday already? I've got a Joseph Cunningham on my docket for Friday. I don't know if it's the same individual.
Yeah. It's got a 6.
16 is last year.
Yeah. There's a note on there that says 6/14.
614 for a bond forfeiture.
Okay.
So he must have picked it up.
He was picked up.
Picked up?
He was picked up last night, Mr. Steiner.
He has a bond question. So he is.
Why don't we do this? Given that nothing's done on this case, I am going to make sure you're appointed, Mr. Steyer, if you weren't already. And it's on for a bond forfeiture on Friday. So we'll just handle this case on Friday with the bond forfeiture. I don't know whether the bondsman is going to want to stay on this or not. And I don't want to set a new bond until we're aware.
Right.
All right, so this matter is going to be continued over to June 14th for set with the bond forfeiture and a pretrial.
Thank you.
Excuse me, if you're listening at the jail, we're not going to do Mr. Denny right now. It'd be State of Ohio versus Kyle E. Jadwin, case number CRA 24358.
Your Honor, may I approach?
You may. Let's go and call it. Well, we got this. This is State of Ohio versus Kyle E. Jadwin, CRA 24358. Mr. Jadwin, can you hear me?
Yes, sir.
All right, this is a Rule 4 hearing on a bench warrant out of Muskingum County that alleges you failed to appear for court on April 23rd of 2024. Are you aware of those charges, Mr. Jadwin?
Yes, sir. My mom tried to call my lawyer and tell him I was incarcerated and stuff.
Okay. There are two options that you have here. You can waive your right to a Rule 4 hearing, and then I will give Muskingum County a period of time to come and pick you up, take you back there. Or I can set a bond for you if you think that you can make that bond. They are requesting a $5,000 cash or surety bond, which would probably cost you about $500 through a bondsman. If you think you can make that bond, I will allow you to bond out and present yourself to Muskingum County on your own accord. Is that a bond you think that you can make?
I'm not sure if I could. I'm here on minute reads and rehab, and I'm down here getting help.
Okay. There's a worker from Men's Reads that's going to have to speak, I believe, and has some question about that.
Yes, Your Honor, that is correct. Mr. Jadwin is a client of ours. I'm unsure on the standing of bond, but I also do understand Rule 4 hearings and how they do work. I don't believe we had any awareness of the issue in Muskingum County, or we would have already been in the process of taking care of it. So we are willing to do whatever we need to do on our end within feasibility. If Mr. Jadwin has the ability to make bond, otherwise we'll work with Muskingum County to hopefully get him back in treatment if he chooses to waive his preliminary.
Okay. All right, Mr. Jadwin, here's what I would be willing to do. Since there is a treatment provider, I'm willing to give you an OR bond to treatment, back to treatment. But you will have to appear, and I'll give you, and the treatment provider will be required to, they'll be inpatient, and the treatment provider will be required to transport you to Muskingum County. And you're okay with that as?
That's correct, Your
as a
Honor.
provider?
Yes, sir.
Okay. Do you wish to waive your Rule 4 hearing then?
Without being to the minute read to go back there?
If you're willing to waive it, I will
Yeah.
give you the bond, send you back to Minute Reads, and let them take you to present yourself in Muskingum County.
Yes, sir.
Okay. I think you'll have to sign a waiver going down to jail. Okay, so here's going to be the order. I'm going to note your waiver. Give you $1,000 OR bond, release to Mended Reads. You will have until, I'm going to set you back here on June, you'll have until June 17th to appear in Muskingum County. I'm going to set you a pretrial here on June 17th. If you haven't appeared in Muskingum County by then, you will have to appear here to explain why. If you have appeared and we have confirmation of that, then the matter here will be dismissed. Okay?
Thank you.
Thank you.
Thank you, Your Honor.
Thank you.
State of Ohio versus Cowlings Walker, case number CRA 24357. Christopher Ferris is on deck.
This is State of Ohio versus Talmadge Walker, case number CRA 24307. And this is on an out-of-state extradition to Kentucky. Mr. Talmadge, can you hear me?
Yes, sir.
All right. We're here on for an extradition hearing today on whether or not you should be sent back to Kentucky. It looks like that there is a warrant for you out of Kentucky for non-support. And So do you wish, you have the right to have a full hearing and make them come in and produce a governor's warrant. But you can also, if you know that this is you and you want to get this moving, you can also waive that right to your extradition hearing. And if you waive it, then I will give Kentucky probably a week to come and pick you up and take you back. If you wish to have a hearing, the state of Kentucky will have a period of time, I believe it's about 30 days, to produce a valid governor's warrant for hearing. And during that time frame, you would remain in Lawrence County Jail. So, do you wish to have a full hearing, or do you wish to waive your right to extradition?
I wish to be extradited.
Okay. I will then note the waiver. There will be a paper you'll have to sign down at the Lawrence County Jail, and I will give Kentucky has until June 17th to pick you up. If they haven't picked you up by the end of business June 17th, you'll be ordered as released. Any questions, Mr.?
No, sir.
All right. Okay. So if they haven't picked you up by 8 a.m. on June 17th, you'll be released.
All right.
All right, thank you.
State of Ohio versus Christopher L. Ferris, case number CRA 24359.
So the state of Ohio versus Christopher L. Ferris, CRA 24359. Mr. Ferris is present via Zoom. We are here today for an extradition, matter of expedition. Can you hear me, Mr. Ferris?
Yes, sir.
Okay. Mr. Ferris, the state of Kentucky is wanting you back. They're alleging that you left the rehab and that you committed a crime of fleeing and wanton endangerment.
What?
Fleeing and wanton endangerment is what's on the... So,
What's wanting endangerment?
I'm not a Kentucky attorney. I can't advise you as to over there what that is. But you have a right to have the state of Kentucky. You can have a full hearing. You have the right to have the state of Kentucky produce a valid governor's warrant during that time frame. They have a reasonable period up to about, I believe, 30 days to do that. Or if you believe that if you know that you are the Christopher Ferris that they are looking for and you wish to waive your extradition, I will give them essentially a week to come and pick you up. And if they don't pick you up during that time frame, you'll be ordered as released. Do you wish to have your matter heard on a full extradition hearing, or do you wish to waive your extradition hearing and go back to Kentucky? Okay. So I will give Kentucky a week until June 17th at 8 a.m. to pick you up. If they haven't picked you up by then, you'll be ordered as released. Yeah. And Mr. Ferris, I'm also going to set that for a pretrial on June 17th at 10 a.m. here. In case you haven't been released, you'll have to appear here. If you've already been transported to Kentucky, we'll receive verification of that and we'll dismiss the matter here on our end. All right, thank you very much. And on CRA 24357, I'm likewise going to set a pretrial for June 17th at 10 a.m. in case he has not been released.
State of Ohio recalls, State of Ohio versus Donald L. Denny II, case number CRA 24335, CRB 24336. That's Mr. Morgan's case. He's got
Mr. Morford?
I believe he's on the phone with Joe.
Here, we'll pass this then, and we'll pass the matter to later in the docket.
State of Ohio recalls Brian J. Finley, case number TRC 23-53, A and B.
This is State of Ohio versus Brian J. Finley, TRC 23-153, A and B. It was set for review this morning at 9 a.m.
Your Honor, he was taken into custody and sent to prison about 2 months ago through felony court.
Okay. I will then issue a bench warrant for failure to appear for the hearing. You may have a pretty valid excuse for that, but he'll still have to appear once he is released from prison here. And so we'll see him back whenever he is released. Thank you, Your Honor. We're going to move on and do some pre-trials now. So if you have a pre-trial, please come in the courtroom, and I'll need all the attorneys and the prosecutor in the courtroom.
State of Ohio versus Daniel Bryant, case number CRB 24-93.
This is State of Ohio versus Daniel Bryant, CRB 24-193. Present in court is Mr. Bryant, which is Attorney Crystal Lauder, and present on behalf of the State of Ohio is Attorney Philip Field. Matter set for pre-trial.
Your Honor, I think we have a resolution to this. I believe the state's willing to make a motion to amend the charge to a violation of 2917-11. Disorderly conduct, misdemeanor of the 4th degree. I believe in return for that, Mr. Bryan intends to enter a plea of no contest with a stipulation to facts sufficient for a guilty finding.
And that is what we've agreed to, and we've consulted with the victim on that. And one thing is that we would need a no contact.
Okay. Mr. Bryan, is that correct?
Yes, sir.
You just enter a no contest plea?
Yes, sir.
Okay. Based upon the plea entered by Mr. Bryant and his stipulation to the guilty finding, I'll accept the no contest plea. There'll be a guilty finding. Is there a recommendation on the sentencing?
Other than the no contact order, Your Honor, we would make no other requests.
Okay. I'll order a 10-day jail sentence, all suspended. $50 fine. Court costs. 2 years level 5 probation, so it'll be non-reporting. And there'll be a no contact order while on probation, so you won't be able to have any contact, go around Tommy.
Thank you, Your Honor. I'll have him see the probation officer before he leaves. Excuse me?
I've got to set a review.
Oh, I'm sorry.
Yes, it'll be, the plea will accept the amendment. It'll be a 29-17-11 disorderly conduct in 4, and that's what we sent it on. And we need to set a review hearing.
Your Honor, I don't know if this helps you any, but he intends to pay the fine and court costs before he leaves today, so I don't know if you'll need a review hearing. Is there any other requirements?
Well, here's what I'll do. I'll set the review hearing, so long as the fine and court costs are paid, you don't have to hear.
Okay.
I'll set that review for October 21st.
Thank you, Your Honor.
Thank you. Thank you, Mr. Bryan.
Thank you. I just hang out there for a minute. I'll be out there in a second.
October 21st, 9 a.m.
State of Ohio versus Lynn R. Logsdon, case number PRC 24-554, A and B. Lynn Logsdon.
Judge, Ms. Logston's not here. She,
Hang on, let me pull the case.
oh, I'm sorry.
This is PRC 24-554 A and B, State of Ohio versus Lynn Logsdon. Ms. Logsdon is not present. Her attorney, Mr. Delauder, is present on her behalf. State's represented by Attorney Cofield.
Thank you, Your Honor. Ms. Logston is on standby to log on via Zoom, should we have gotten her case resolved. I talked to Mr. Gill a little bit about it. We don't have it resolved yet. What I'd like to do is probably file a suppression motion in the case. I can have that done in relatively short order. If you want to reset this for a pretrial in a couple of weeks, that would be fine. Maybe, I don't know what the court's docket looks like on the 24th.
24th of June.
Hey, Chris.
Just, Your Honor, on second thought here, after further conference with Mr. Hill, I think we do have this resolved.
Okay. We'll recall this. So
yes, I'll have to get her log on.
We'll recall this later in the docket.
State of Ohio versus George M. Massey, case number CRB 24-124.
So the State of Ohio versus George M. Massey, CRB 24-124. President Courts Mr. Massey, along with his attorney Mr. Delauder, and the State of Ohio is represented by Attorney Cofield. That is set for trial.
I believe that the state is agreeable to dismiss this case on payment of costs, Your Honor, and my client doesn't have any objection to that.
Okay. Mr. Gill?
That's correct, Your Honor.
All right. Has the alleged victim been assaulted in this matter?
Yes.
This matter will be dismissed upon payment of costs.
I'll have him see the clerk right now.
Okay. Thank you.
Thank you, Your Honor.
Your Honor, we're going back to Lawrence County Jail. State of Ohio versus Donald L. Denny, the second, case number CRA 24-335. Heather Crager is on that.
This is State of Ohio versus Donald L. Denny, the second, CRA 24-335. Mr. Denny is present via Zoom. His attorney, Mr. Morford, is here in the courtroom. State of Ohio is represented by Mr. Phil Keel. And it looks like this matter is set for a preliminary hearing today. Is that correct?
Yes, Your Honor. Mr. Denny, can you hear me? This is much more for your attorney. The question before the court this morning is whether or not you want to have a preliminary hearing, or do you want to waive your case to the grand jury and keep your bond the way it is?
I'd like to proceed with preliminary.
Okay.
All right, this will be recalled later in the docket at the end for evidence.
Thank you, Your Honor.
State of Ohio versus Heather N. Crager, the Lawrence County Jail, case number CRB 19-732, CRB 24-104.
State of Ohio versus Heather N. Crager, CRB 19-732, CRB 24-104. Ms. Krager is present via Zoom at the Lawrence County Jail. Attorney Mr. Morford in the courtroom, and state represented by Attorney Philip Hill. This matter was set today for second arraignment on failure to appear. Mr. Morford.
Judge, with respect to her failures to appear this year, March 25th and April 8th, she was on the run after having left rehab against staff advice. She was inpatient, I believe, at Bethesda, and if Bethesda would have her back in the court, and Mr. Hill would agree, she wants to go back to inpatient treatment.
Taylor, thoughts?
Sure.
Well, here's what I'm going to do. I don't think that Ms. Krager, after being on the lam for a little while, and she hasn't done anything on her own case, so I'm going to allow her to go back, but I'm not going to. We're going to review this on Friday, and I will set the bond and allow her, if they've got a bed available on Friday, to go rather than go today. I think she needs a few days to think about what she's been doing. So we'll add this on Friday's document for June 7th, or excuse me, June 14th at 10 a.m. for pretrial, and if Bethesda is still willing at that point, then I will release her at that time to treatment at Bethesda.
Ms. Krager, do you understand what the judge is doing? He's going to give you like a trial period this week. You hold the key in your hand. If you do what you're supposed to be doing, exert the effort, then I would expect the court to consider keeping you there. So you need to get clean and compliant and do whatever Bethesda asks of you.
So I will be here till Friday.
Yes.
Okay.
Thank you, Your Honor.
Thank you.
If the jailer is listening, the only thing we have left at the jail is Donna Jennings. We'll be calling it quite a bit later in the docket. State of Ohio versus Jada M. Patterson, case number TRC 24695, A, B, and C.
State of Ohio versus Jada M. Patterson, TRC 24695, A, B, and C. Ms. Patterson is present in court with Attorney Mr. Lauder. State of Ohio is represented by Attorney Philip Hill. It's a matter set for pretrial.
Your Honor, it's my understanding that Ms. Patterson intends to change her plea at this point after conversation with Mr. Hill about the circumstances surrounding this case. Okay. The two guilty.
Ms. Patterson, is that correct? You understand her guilty plea?
Yes.
Yes.
I will accept your guilty plea and enter a guilty finding. Is there a recommended sentence by the state in this matter?
Your Honor, this is a first offense. The breath alcohol score was .134. We would request the mandatory minimum as far as the incarceration and suspension thereof and the DIP program. We would take no position on the fine. We'd ask for a 6-month driver's license suspension.
Okay. Mr. Lauder.
We have no objection to that recommendation, Your Honor.
Okay.
We would ask that the suspension start. There was a breath score, as the state indicated. We'd ask that the suspension start from the time of her stop, which was April 4th.
Okay. I will go ahead and Ms. Patterson will go ahead and end her sentence at this time. It's going to be 10 days jail, all suspended. You'll have to do the 3-day DIP school. That's mandatory under state statute. I will give you the minimum fine of $375. That's the minimum I can give you by statute. Or you can pay the court costs. There'll be a 6-month suspension of your license. It'll date back to April 4th, so it'll start from that point going forward. Be 2 years. Level 5 probation, non-reporting. Mr. Hill, there's a B and a C case on this. Are you wishing to deny those? Well, I guess
I guess the A case is the A1A.
Right.
So we would nolly that one, and we would nolly the Mark Lanes.
Okay. The A case and the C case.
RA case is showing me the other.
Okay.
But the B case is also probably.
Yeah, technically. The Mark Lanes will be nollied. All right. Ms. Patterson, you'll need to see probation, and then you'll be free to go.
Review hearing, Your Honor.
Be a review hearing December 9th. At 9 a.m.
Thank you, Your Honor.
Thank you.
State of Ohio versus Michael Ward, case number TRC 2436, A, B, and C.
So the State of Ohio versus Michael Ward, TRC 2436, A, B, and C. Mr. Ward's present in court with attorney, Mr. Bellotta, state's represented by Attorney Cole. Matter is set for pre-trial.
Your Honor, I believe it's Wood, by the way. I don't know if the file says Ward, but.
I just looked at it incorrectly.
It's Michael Wood.
The O and the D are kind of overlapping, so it looks like an R, so it's Michael J. Wood.
Yes, sir. In any event, Mr. Wood, after speaking with Mr. Heald, I believe Mr. Wood wants to change his plea to no contest with the stipulation of facts sufficient for a guilty finding. However, we don't want to, we would like to have a sentencing hearing at a later date.
Okay. Mr. Wood, is that correct?
Yes, sir.
All right, I accept your no contest plea, and based on the stipulation, enter a guilty finding. Do you have a specific date you're looking at?
Part of the resolution, Your Honor, in this case involves Mr. Wood's continued treatment. He's already actively involved in treatment, has been for quite a while. July gets really busy. I don't know if August 5th is too far out. If that's all right with the court, that'll give Mr. Wood plenty of time to get further treatment under his belt.
I'll set a sentencing hearing for August 5th, 2024 at 10 a.m.
Where is he attending?
Pathways. He's a Kentucky resident.
Yes. After that sentence hearing, I'll go after that. Anytime after. Okay.
State of Ohio versus Leah R. McDowell, case number CRB 24251.
This is the State of Ohio versus Leah R. McDowell, CRB 24251. Ms. McDowell is President Court Attorney Mr. Delauder. State represented by Attorney Phil Field.
Your Honor, Ms. McDowell wants to change her plea to guilty today.
Is that correct, Ms. McDowell?
Yes.
I'll accept your guilty plea and go ahead and enter a guilty finding. Is there a recommendation as to sentencing?
She already, I had her already submit to a urine screen, Your Honor, thinking that you may want her to do that anyhow. She was clean of everything except for the prescriptions, her prescription medication. The only perhaps unusual request in this case is, I don't know what kind of community service requirements are likely to be imposed. However, Ms. McDowell asked me if the court would consider maybe an increased fine or some kind of light duty. She's got knee surgery scheduled and back issues that she's afraid will prevent her from doing a lot of community service that might normally be ordered.
Well, Mr. Blotter, on these, the community service is pretty standard, but I believe that they do have light duty. Ms. McDowell, I'm going to sentence you to 10 days in jail. I'll suspend all of them. You're going to have a $50 fine, court costs. There'll be 30 hours community service, but again, that can be done on light duty. Be 2 years level 4 probation. And what was our review date? December
December the 9th.
Okay. Now I'll set a review hearing for December 9th at 9 a.m. If you have everything taken care of by then, you won't need to appear. But if you have anything left that you haven't gotten done, you'll have to appear and explain why you want it.
Thank you.
Thank you, Your Honor.
You'll need to check in on probation before you go.
I'll have her do that and talk to probation before you leave, but I'll be out in just a second.
State of Ohio versus James A. Markham Jr., case number CRB 24230 A, B, and C, CRB 24296.
So, State of Ohio versus James A. Markham Jr., CRB 24230 A, B, C, CRB 24296. Mr. Markham is present with his attorney, Mr. Hill, State's represented by attorney, or excuse me, by Mr. Delauder, State's represented by Mr. Hill.
Your Honor, Mr. Hill's indicated to me, unless something's changed, that he intends to present this case to grand jury. In light of that, Mr. Markham's willing to waive his right to a preliminary hearing and ask that his bond continue.
Okay. Mr. Markham, is that correct?
Yes, sir.
All right. Mr. Hill, do you wish to take the misdemeanors over as well?
I'm sorry, Your Honor.
Do you wish to take the misdemeanors over as well?
They all occurred at the same time, so yes.
Okay. Mr. Markham will need to sign a waiver.
Your Honor, I've talked to Mr. Markham about his rights related to a preliminary hearing prior to coming into court today, and he's executed just now a written waiver of those rights and understands this case will be bound over and just asks that his bond be continued.
All right. I will accept your waiver. I find it was knowingly, voluntarily, and intelligently given. And I will note that the bond is continued.
Thank you.
May I approach on an unrelated matter?
Thank you. You bet. Fair enough.
State of Ohio versus Lynn R. Logston on a recall case number TRC 24554 A and B.
This is State of Ohio versus Lynn R. Logston, TRC 24555 A and B. Ms. Logston is present now via Zoom. Ms. Logston, can you hear me?
Yes, sir.
Okay. Her attorney is also present, Mr. Delauder, state's represented by Attorney Phil Field. This matter is set for a pretrial. My understanding is there's a resolution.
Your Honor, I believe there is. I believe that the state's willing to amend the charge in this case to a violation of 4511-194, physical control. In return for that amendment, it's my understanding Ms. Logston intends to change her plea to guilty. I've talked to Ms. Logston about this prior to coming into court today, and I believe she understands the recommendation.
Okay. Is that correct, Mr. Hill?
It is, Your Honor, and having reviewed everything related to the evidence in this matter, we believe that it's an appropriate resolution.
I will accept the amendment. Ms. Logston, is what your attorney represented in the court correct? Do you wish to enter a guilty plea?
Yes, sir.
Okay. To the amended charge, I will accept your guilty plea. I'll enter a guilty finding. And is there a proposed resolution in this matter?
Did we talk about the school?
She will.
We'd like for her to attend the 3-day driving school, Your Honor. We take no other position.
Okay. Are you wanting to go ahead and do the sentencing and make that part of probation, or do you wish to come back for something on another day?
Let's do it, make it part of probation.
We can make it part of probation, Your Honor.
Okay. The B case, there's a B case, it's a parking prohibition. Mr. Gill, what do you wish to do in the B case?
Parking prohibition. We would dismiss that.
Okay. B case will be denied. There'll be on sentencing, Ms. Logston, I'm going to order 10 days jail. I'll suspend all of them. You'll have to go do the 3-day driver intervention program, 72-hour driver intervention program. That's going to be part of probation. There'll be a $150 fine, court costs, 2 years level 4 probation, and you'll have a review hearing on December 9th at 9 a.m.
Your Honor, would you permit her, she doesn't live around here, that's the reason she's appearing via Zoom today. Would you permit her to phone in for reports to probation? Unless they request otherwise of her?
I think that's, is that, how,
Is it level 4, level 5?
it's level 4.
It's reporting every other month, but she can work out with Mr. Major, who probably approve with phone in.
Okay, I'll leave that up to probation.
Thank you.
And I don't have a problem with her going to level 5 probation, once her 3-day DIP school is completed, which I believe will be non-reported.
Okay, thank you.
Ms. Logston, you'll need to phone in and speak with probation to get everything set up later today.
Yes, sir.
I'll call her and give her that information.
All right, thank you, Mr. Blotter.
Thank you, Your Honor. Your Honor, you asked me to remind you about a sentencing hearing that I have related to Austin Smoot. I have talked to Mr. Hield about that, and we are able to resolve that today, if it's possible to call it. Thank you.
State of Ohio versus Austin Smoot, case number TRC 24-176 A and B.
This is State of Ohio versus Austin Smoot, TRC 24-176 A and B. Mr. Smoot's present with his attorney, Mr. Blotter. State's represented by Attorney Phil Keel. This matter is set as a sentencing hearing today, and Mr. Smoot has been in treatment.
That's correct, Your Honor. Mr. Smoot had entered a plea to an OVI offense quite some time ago. He's been in treatment with RRS since that time. I believe he's done very well in treatment there according to the update reports that we've received from them. Part of the contemplation when he entered his guilty plea was that if he could prove to the court and the state that he was going to do well in treatment, that for sentencing purposes, this could be treated as a first offense so that Mr. Smoot could avoid jail time, at least immediately. I believe he's held up his end of the bargain on that, and we'd ask the state to recommend a sentence in accordance with that.
Okay. Mr. Smoot, I was handed a report on your progress. It looks like you've been in treatment about almost 4.5 months, and all the reports that I've seen have been excellent reports, and so you should be commended for that.
Thank you, sir.
Mr. Hield is what has been talked about by Mr. Blotter, all correct?
Yes, and it is a commendable report, so I hope Mr. Smoot feels good about himself about this. The goal is to make this a permanent change.
Yes, sir.
Because Mr. Smoot's a young man, and he's got a long life to live, and the fewer things that he has holding himself back, the better. I don't know that it's time yet to say that he's completed his treatment.
He's getting close.
So what we'd like to do is, when do you think would be the date?
Within the next month or two.
So maybe if we came back in a couple months just to put a bow on it and say that he's completed. Our goal is to be able to recommend that he doesn't go to jail. Right now it's a second offense high score. And he obviously was in need of this, and we want to see it follow through with all of it.
We have no objection to that, Judge. August 5th, I've got another hearing we just set, so if that date works for the court, hopefully he'll be done by then. That's
That date does work for the court. Mr. Smoot, keep doing what you're doing. Hopefully it'll be completed by then. This matter will be set for sentencing on August 5th at 10 a.m.
Thank you, Your Honor.
Thank you, sir.
Thanks for taking that case up.
No problem. Thank you.
State of Ohio versus Samantha Cooper, case number CRB 2472.
To the State of Ohio versus Samantha Cooper, CRB 2472.
Your Honor, she's here by Zoom.
Ms. Cooper is here via Zoom. And with her attorney, Mr. Thompson, the state's represented by Attorney Phil Field. And I see, I believe she's in treatment with Bethesda. Is that correct?
Yes.
We've had a couple of hiccups with her treatment.
She's not been attending services or coming in for random screens. She said she's had some car issues and she's communicated that to her counselor. She has this week to get compliant or she goes into residential.
So we'd ask it to be continued 1 week.
Okay.
And we put a continuance in the folder.
All right. Ms. Cooper,
Yes.
did you hear what your attorney has indicated to the court?
Yes.
All right, you heard what the treatment provider has indicated to the court.
In what?
Did you hear what your treatment provider has indicated to the court?
Yes, yes I did.
Okay, you have been non-compliant. You don't have a choice at this point. You're either going to get compliant or you're going to end up in residential treatment or jail.
Okay.
Do you understand that?
Yes.
If you don't get compliant and either of those two things happen, I don't want it to be a surprise to you.
Okay.
I am going, let me double check the calendar. All right. I am going to approve the continuance and allow you a week to get compliant. However, you are not allowed to appear on Zoom for your next hearing. You are to be here in person June 17th at 9 a.m. Do you understand?
Yes.
There will not be a week to get you to come in or a continuance granted for you if you don't show up. There will be a bench warrant issued and you're going to jail. Do you understand that?
Yes.
Okay. I'll approve that. Then, based upon that being submitted by both Mr. Hill and Mr. Thompson, and this is your last shot. So I'll see you back on what day?
June 17th.
What time?
At 9 a.m.
All right, I will see you, we'll see you back then. Thank you.
Thank you, Your Honor.
Thank you.
State of Ohio versus Donald Knight, case number TRC 24750.
So the State of Ohio versus Donald Knight, TRC 24750. President courts Mr. Knight with his attorney Mr. Thompson, and Mr. Field is representing the State of Ohio. This matter is set for a free trial today.
Your Honor, the case involved a urine screen that was given, and we received the test was both for alcohol and drugs. We received the alcohol portion back, and it was well under the legal limit, almost to the point where it was 0.02 in the urine, so very, very low. But the drug portion of the screen is still pending, so we'll need more time.
Is the state wishing then for continuance to get that in?
Yes, Your Honor.
All right. Mr. Field, how long do you want to go out, and what day would you prefer to come back?
Well, the 90-day limit is on July the 7th, so we would need to come back before then, probably before about 2 weeks, probably.
And Monday if possible, Your Honor.
Okay. How about June 24th? Do you think that'll be enough time, Mr. Hill?
I think that would be appropriate, Your Honor.
June 24th.
All right. The matter will be continued at the state's request to June 24th, 24 for pretrial hearing.
Thank you.
State of Ohio versus Jennifer Cooper. Case number CRB 23506, CRC 231127, A, B, and C, 23 CRA 507.
The State of Ohio versus
Jennifer Cooper.
Jennifer Cooper. Jennifer Cooper, you look on the courtroom. The State of Ohio versus Jennifer Cooper, CRB 23506, PRC 231127. President Court Mr. Cooper with her attorney, Mr. Thompson, states represented by Attorney Philip Keel. Ms. Cooper has been in treatment for a little while.
There's an end date on
August
treatment
19th.
of August 19th, so if we could continue it till right before then. Any given Monday.
Prefer Monday.
Please.
Well, why don't we do what you said for August 19th? Let's just set it for August 19th. All right, Ms. Cooper, you're doing wonderful. All your updates have been great.
She's done very well, Your Honor.
I was going to say, I looked at this a little before coming in the courtroom, and all your reports were exceptional, and the court takes note of that and really appreciates that. It doesn't always go so well, so keep doing what you're doing. You're doing a great job, and then hopefully, when we come back in August, we'll be able to wrap this thing up and congratulate you on your graduation.
Thank you, Your Honor.
Thank you.
Thank you.
Thank you, Your Honor.
State of Ohio versus James C. Thompson, case number CRB 24361.
This is State of Ohio versus James C. Thompson, CRB 2436. Matters set for arraignment this morning.
I just wanted to let y'all know.
Matters set for arraignment this morning. All right, Mr. Thompson. It's alleged on or about June 9th that you, without privilege to do so, knowingly entered or remained on the land of another. It's a violation of Ohio Revised Code 2911-21A1 criminal trespass. Mr. Thompson, how do you wish to proceed? All right, I'll take your silence as a not guilty plea. So I'm going to enter a not guilty plea on your behalf. I'm going to allow him to sign a $500 signature bond. Mr. Thompson, are you working anywhere?
If I may, I think this might be the case where we need to get an attorney to.
I just wanted to make sure. I'll hear from his uncle on that. Is he
Yeah.
working anywhere?
No, he's on SSI.
Okay. I'll find that he meets the requirements for court-appointed counsel, and I will appoint Mr. Morford to represent him.
You got his phone. Yes.
And we'll set this matter for a pre-trial July 8th. At 10 a.m.
Thank you, Your Honor.
Thank you.
State of Ohio versus Scott R. Tierney, case number CRB 24263.
The State of Ohio versus Scott R. Tierney, CRB 24263. Attorney Tyler Smith's case, Mr. Tierney's present next hearing, as well as the State of Ohio is represented by Philip Healy. Matter set for pre-trial.
Your Honor, I've talked with Mr. Hield, and we have a disagreement on the recommendation, so we just need to set this for a trial.
Okay. Do you have any recommendations on when you want that set? Looks like we're still pretty early in the process.
Yeah, in fact, maybe even set one more pretrial, but I don't know if anything's going to be resolved at that point. But
Why don't we do this? Let's set a pretrial and a trial date. That way we've got
That's fine.
something to work towards if it doesn't work out.
that works fine, Your Honor.
Why don't we do this? Let's set the pretrial for July 8th. At 10 a.m. And we'll set the trial for July 15th, a week later. At noon.
Your Honor, this is alleged to have occurred on May the 4th, so we're talking about the time limits right around that time. There'd need to be a time waiver to move out that far.
It's M1, it's less than 90 days in July. May 4th to July 15th is only well over 2 months.
Oh, I'm sorry, that's only 16. Okay.
Well, I'm not waiving time at this point, so.
Okay.
I counted wrong.
Okay. It'll be set for pretrial July 8th at 10 a.m. and trial July 15th at noon.
Thank you.
Thank you.
State of Ohio versus Sean Crabtree, case number CRB 24228, CRB 22494. Mr. Stratton's case.
All right, this is case number CRB 24228, State of Ohio versus Sean Crabtree. Mr. Crabtree is not present, and I've not seen his attorney here today. All right, we're going to pass on this and recall it if you want to have someone reach out to Mr. Stratton's office.
Yes, Your Honor.
Okay, we'll do the same with those.
Okay. State of Ohio versus Lee Kipp, CRB 23211. State of Ohio versus Sid Mosser, case number CRB 24258. And State of Ohio versus James Sarton, case number TRC 24897, A, B, and C.
Okay, those are all going to be passed, and if we'd have the clerk reach out to Mr. Stratton's office and see where he is.
State of Ohio versus Chris Losey, case number CRA 24302 and CRB 24303. CRB 2921.
This is State of Ohio versus Chris Losi, CRA 24302, CRB 24303, CRB 2921. And this is Mr. Steyer's case. Mr. Steyer is present, and it looks like his attorney may not, or his client may not be. Mr. Keel is representing the State of Ohio.
Your Honor, my understanding was that he was to be released to OVP. OVP isn't here this morning. Do we know if he was released from the jail?
He's not on the jail list.
Not listed on the jail list, and I do have a note that he was to be released to OVP.
I'm sorry, you don't have that note?
I do have a note that
Okay.
he was to be released.
What I'd like to do then is ask to have this recalled while we do some research, see if we can figure out if he's with OVP, and if so,
Okay,
get him on video or here or rescheduled.
okay. We'll recall this later in the docket.
Thank you.
Thank you.
State of Ohio versus Austin Pritchard, case number CRA 18-1233 A and B, CRB 18-1234 A and B.
Your Honor, this matter is...
Let me get the case.
Oh, I'm sorry, go ahead.
This is State of Ohio versus Austin Pritchard, CRA 18-1233 A and B, CRB 18-1234. Matter is set for pretrial on review. Mr. Pritchard is present, Mr. Steyer.
I don't think I've been reappointed on this, so I think this is one that's on post-conviction, so I'm not actually involved at this point.
Okay.
It's Morford.
Say it's Morford?
Yeah, I think it's Morford.
He says Mr. Morford's been appointed at this time.
Yeah, he's.
If Mr. Morford's here, can he come in the courtroom?
He's
What's that there for him?
Yeah, he's been like 6 years. 6 years.
Your Honor, while we're waiting on Mr. Morford, as you can see on the report, he has been compliant. We have had no issues with drug screens as per our last hearing. He's been doing very well. He's also being monitored by the Common Pleas Court, who is currently pleased with his process. They put him in with us during Project Bridge. So he's been doing very well and has been compliant with both courts at this time.
Okay. How far into the program is he?
He approximately a month. I believe he's looking at possibly going to the next phase in treatment within the next week or two. I do need to say this, not that he will do anything against that, but pending compliance. So he is moving along. If he has no non-compliances throughout his entire treatment, he's looking at approximately 2 more months before an official graduation.
Mr. Morford, how's your calendar for July 15th?
Not good. I have a trial in common pleas court, Your Honor.
Okay. 22nd?
I'm here then.
We'll come back July 22nd at 10 a.m. for use and sentencing.
Thank you, Your Honor.
Thank you. Keep up the good work.
Yes, sir. Thank you.
Thank you, Your Honor.
Thank you.
State of Ohio versus Jonathan T. Register, case number CRB 24-159 A and B.
So the State of Ohio versus Jonathan Register, CRB 24159. President Court is Mr. Register, with his attorney Mr. Steyer. State of Ohio is represented by Attorney Clerk Field. Matter set for pretrial.
Your Honor, if I may, I'm going to make an appointment with Mr. Register to go over discovery. I think we can get this, but I anticipate we'll have this wrapped up on another court day. Due to my schedule and just the size of certain dockets at this point, I would like to ask if we can continue this to July 1st, and we would waive time constraints to accomplish that.
At defendant's request, this matter is continued to July 1st for a pretrial at 10 a.m. I'll note the time waiver as well. Thank you.
Yes, sir.
Thank you.
State of Ohio versus Sean Crabtree. Excuse me, Your Honor, that's the wrong case. I shouldn't call it. State of Ohio versus Thomas W. Ward II, case number CRA 24259.
State of Ohio versus Thomas W. Ward II, case number CRA 24259. Mr. Ward's present with his attorney, Luke Steyer. Mr. Fields representing the state of Ohio, and we're set here for a preliminary hearing.
Your Honor, this matter is one that the state has agreed to keep here until our pending Mr. Ward's success in treatment. He is at Mended Reeds right now. There's a representative here with a report. He's doing well. It's my anticipation the state would probably want to follow this a little bit further. So I don't know what kind of a time frame the state or the court believes is appropriate to return on this.
Your Honor, Mr. Ward is fairly new in our program. He is still in the 3.7 level of care, which I know does not give a whole lot of information to the court, but he is very new. We're still looking at, the possibility of 3 to 4 months pending compliance before a possible graduation date.
Okay. Mr. Steyer, what does your schedule look like for July 22nd?
I currently have a jury trial. There's a pretty good chance that's not going to happen though, actually, so.
29th.
29th is clear.
Okay, let's set this for July 29th for preliminary hearing.
I'd like to make a correction, Your Honor. The client is informing me that he has since graduated the 3.7 and is currently at 2.5. And went that on Sunday. I will have to confirm that, but I would just like that on the record that the client did state that he has done. But the reports are a week behind, so there is the possibility that that is correct.
Okay. We'll come back July 29th, and then hopefully we'll have all that cleared up by then.
Absolutely.
Where things are and where they stand.
All right.
Keep doing what you're doing, Mr. Ward.
Yes, sir.
You're clearly progressing and doing well, whether you've graduated to the next step or you're getting ready to, you're progressing, and that's what we're looking for.
Yes,
So
sir.
Keep doing what you're doing.
Thank you, Your Honor.
Good job. Keep it
Thank
up.
you.
Thank you.
Thank you.
State of Ohio versus Sean A. McComas, case number CRA 24-2. Sean McComas.
So the state of Ohio versus Sean A. McComas, CRA 24-2. Sean McComas.
Your Honor, if I may, this matter was to be dismissed on payment of court costs. I confirmed with the clerk's office the costs have been paid.
Okay.
And we were here about a week or two ago, and the judge said no appearance was necessary if costs were paid.
I see the note on that. All right, this matter will be dismissed.
State of Ohio versus Justin Neese, case number CRA 2317.
State of Ohio versus Justin Neese, CRA 2317. Mr. Neese is present with his attorney, Mr. Luke Steyer, state's represented by attorney Philip Keel. Matter set for preliminary.
Your Honor, Mr. Neese is an OVP. We have a report.
Excellent report. Looks like there's a graduation date projected for June 29th.
Your Honor, with that in mind, the state and I are discussing the possibility of this matter remaining here, but we don't have a firm agreement by the state long-term, but the state is at least agreeable to sticking here long enough to get him through the inpatient treatment. So I'd like to ask to have this set for July 1st, at which point, if he comes in here successful, I'll raise the issue with the state again. We may keep it here, we may take it on to the grand jury, but we'd at least like to stay here long enough to get him through treatment.
And, Your Honor, I'd like to state for the record why we feel that way is the best way to go. And that is because we believe that restitution in this matter is the most important thing. And while he's in treatment, he wouldn't be able to probably come up with that money. But after he's done with treatment, we would expect that he'd either come up with the money very quickly, which would influence our decision if we could leave the case here. And if it would take him more time, we'd probably send it to the grand jury. But we thought that it was best, particularly because it's a 30-day program, to be done with it fairly soon, but that was the best way to proceed.
All right. We'll come back July 1st at 10 a.m. At the defendant's request.
Thank you.
Thank you.
State of Ohio versus Tanya M. Hardy, case number CRB 24206.
This is case number CRB 24206, State of Ohio versus Tanya M. Hardy. Ms. Hardy's present here with her attorney, Mr. Walford. State represented by Attorney Phil.
I can't read it.
Matter is set for a pretrial.
No, I just,
I still want to see.
okay, yeah. Your Honor, I've been able to speak with Ms. Clark, who's the alleged victim in this matter, and she's presenting going to present some medical records for us. Because apparently there were some injuries which would influence our decision about what we would recommend to resolve this case. And I don't know whether there is need for further discussion on that or whether they want to have a trial.
Well, we're going to entertain an offer.
Okay, well, unfortunately, I don't have one right at the moment.
Do you want to continue it another day?
I'd like to.
I don't have a problem.
Can we subpoena my witness that's seen everything go down?
And yes, we can do that.
Okay.
Judge, it appears we're going to ask you jointly to continue it.
How far out would you like to go?
Judge, Mr. Hill might better answer that. I think he's wanting some medical records perhaps.
And we also have some witnesses which we will, Ms. Clark will let us know about.
And he, the composite took pictures and spoke to my daughter. Or not, spoke to my daughter.
So what we'll do is, can you give me those?
What date was your trial scheduled in July? It's the 8th or the 15th?
The middle on there, Judge. Give me 1 second, please. The 15th, July 15th, Your Honor, is day one of a trial and common pleas.
Okay, you hear the 8th?
That 18th or 19th?
8th.
8th. Yes, Judge, I'm here then.
We're coming back.
This matter will be continued to July 8th for pretrial at 10 a.m. And I want to go ahead and put on record that I can't be the one to hear this case. I've represented Ms. Hardy several times in the past, but given that there's no contested issues today, we can proceed. So the matter will be at the request of the parties, will be continued to July 8th at 10 a.m.
You want to call me?
Yes. Thank you, Your Honor.
Thank you.
You can go on, Jasmine.
Might be escorted to my car. I want escorted to my car.
Well, I don't know if you need an escort.
State of Ohio versus Kathy Knight, case number CRV 24147, A and B.
I need to get a report from you.
So the State of Ohio versus Kathy Knight, CRV 24147, A and B. Ms. Knight's present for attorney Mr. Morford, state's represented by Attorney Field.
May I approach your honor?
You may. All right, Ms. Knight, it's a very good report. Mr. Morford, what say you?
Judge, I'd like to continue on. Do you have an idea when we might, is the graduation date in there?
So March, so we're looking about September.
I don't know if you want to have one or two more before she's expected to graduate or not, Your Honor. September, I believe, is projected graduation date.
Let's come back for a checkup July 8th, starting your here, Mr. Morford, at 10 a.m.
Thank you, Your Honor.
Attendance request.
Your Honor, I'd also like to state some things for the record. That is, first of all, we're encouraged that Ms. Knight is in treatment, taking it seriously, and going to improve her life because of it. The resisting arrest charge is something, though, that is serious and is not something that we just dismiss or disregard because somebody's gotten treatment, because we feel that law enforcement needs to be respected. So regardless of the outcome of this, we're going to expect a resolution on the resisting arrest charge. It would be, as far as our recommendation goes, the difference between whether she was guilty or going to jail or getting a suspended jail sentence. If she were to plead to that charge now, we would delay sentencing, and if she's successful in treatment, then we would agree to recommend a suspended jail sentence where she would not go to jail. So if she wants to do that today and clear that up, if she did that, we would dismiss the disorderly conduct charge.
Do you want to take it back? Do you want to take it back? Yeah. Yes. Do you want to talk about how you're going to do it? Yes, the which.
Judge, do you mind recalling this? Let me.
I don't mind recalling this at all, and for the record, I have some level of apprehension. Mr. Gill, I don't know if you read the report.
It's been a while.
The report that just came in. Actually, Councilor Roach. You guys approach. That'll give you plenty of time to talk to her. Based on that report, I've got some concerns about her being able to do that. Okay? Yeah. Thank you. All right, based upon the pretrial discussions at the bench, we're going to go ahead and set this for July 8th. For pretrial at 10 a.m. That'll give Mr. Morford plenty of time to speak with his client, or to get a little more time in treatment. And to make sure that everybody knows exactly what's occurring. Be July 8th, Mr. Morford.
Thank you, Judge.
Thank you.
Thank you, Your Honor.
State of Ohio versus Stephen R. Scott, case number TRC 2489.
The State of Ohio versus Stephen R. Scott, TRC 2489. Mr. Scott's present in court with his attorney, Mr. Morford, and Mr. Gill representing the State of Ohio. This matter is set for a pre-trial, and my understanding is Mr. Scott is in pre-trial for that stuff.
He is compliant with all service recommendations at this time. I'm sorry, I would have had the fax machines down, I couldn't fax anything.
Okay. Mr. Morford, do you want to come back again on this on the 8th?
Please, Judge.
July 8th, pre-trial 10 a.m.
Thank you.
Thank you.
State of Ohio versus Christopher Thomas, case number CRB 23285. Christopher Thomas.
Christopher Thomas. So the State of Ohio versus Christopher Thomas, CRB 28285. It's Mr. Morford's case. Mr. Thomas has not appeared. The state is represented by Attorney Phil.
I have not heard from you, Judge.
There'll be a bench warrant issued. Thank you, Mr. Morford.
Thank you, Judge.
State of Ohio versus Emily McCoy, case number PRA 193655 A and B.
This is State of Ohio versus Emily McCoy, PRD 193655 A and B. Ms. McCoy is present with her attorney, Mr. Roger Smith. State's represented by Attorney Phil Kegel.
This was an OBI
case that got reopened due to a failed drug screen.
It was the actual overrides. Not still pending. No, well, we're for sentencing.
We're here on sentencing. She'd already been sentenced, but the sentencing on review. And it looks like the only thing remaining in this case is the $100 remaining. To be
No,
paid.
sir,
Your Honor, if
that's,
I may, I believe all that has been done. She done community
Okay.
service and took care of it. And as a matter of fact, she done 2 extra days of community service before we got it.
Okay.
I think we was just waiting on completion later.
Okay, I'm gonna go ahead and make a note that there's nothing left in the file. Yeah, this was from April 25th, so that may have been taken care of. It was an excellent report.
Which, for the record, Your Honor, she has already graduated treatment and is in our transitional program, which is an optional and not even considered part of it. We don't give any kind of certificate for completion of transitional because that's just to give them extra assistance while helping move back into the community. So she has completed treatment. And we have, I believe we've sent that record to Mr. Major, but I'm not sure if it's made her file or anything yet. I can get a copy of that to the court at pretty much any time.
I spoke with my client earlier today, and we would like to go ahead and do, assuming the prosecutor doesn't object. She's done everything she's supposed. She's in a volunteer, optional, transitional living. She's done, sounds like extra community service, but I think we're at that point.
I'm just gonna close this out.
Yes.
The case is closed for community, if she did extra community service, what I'll do is I'll sentence you to the 2 days extra community service that you've already done, and your case will be closed.
thank you so much.
Thank you.
Just to be clear, Your Honor, that ends review hearings as well.
Correct.
She's completely finished.
The case is completely finished.
Wanted to confirm, thank you.
While you may still have work to do at Mendon Reeves and some different things through the transitional program, your commitments to the court are complete. Congratulations.
Thank you so
Thank
much.
you, Your Honor.
Appreciate you, Your Honor.
State of Ohio recalls Chris Losey, case number CRA 24302, CRB 24303, CRB 2921.
It's the State of Ohio versus Chris Lacey, CRA 24302, CRB 24303, CRB 2921, all set for pretrial and preliminary appeal.
Mr. Gwynn has gotten in touch with Ms. Dement from OVP, and I believe has a report to give the court.
Mr. Losey left OVP against medical advice. He ran from the facility.
Okay. There'll be a bench warrant issued for Mr. Lacey for failing to appear and for leaving treatment. Thank you.
State of Ohio versus Micah Ross, case number TRC 213080 A and B.
The State of Ohio versus Michael Ross, PRC 213080, and B.
May I approach, Your Honor?
You may. This is Luke Steyer's case. His client is present. State's represented by attorney. Matter set for a sentencing. It's a good report, Ms. Ross.
She's done well. She's transitioned from residential treatment to sober living just to kind of get her feet solid. She's done really well. She's obtained a job. She's finishing her home health test so that she can have gainful employment. We've not had any issues at all.
Your Honor, this is a first offense OVI. We've been tracking it for some time. Based on the success of this report, I've discussed with the state that it might be a good time to complete this matter if the court feels that's appropriate. I think at this point we've been coming for since December, so about 7 months.
Okay. Is there a recommendation from the state?
Your Honor, we would ask that the jail sentence would not be imposed, would be suspended, whatever the court determined was the appropriate number of days. We would not oppose if the treatment that Ms. Ross is undertaking could stand in place of the VIP program, if that's something that the court, I know that maybe the initiation of the new 3-day driving school might have something to do with whether the court would do that or not. We would not take a position on the fine. We would ask for a 6-month driver's license suspension, but that would go back to the date of the arrest, which was on October 21st of 2021. So it's probably over already.
Well,
we'd ask for her to continue her treatment as part of her program.
Hang on, I have one issue I need to raise with Ms. Ross. Can we just...
Did you have, I mean, this has been forever ago. Did you know if you had insurance done?
Yes, there was insurance in the car.
Did you ever look at it? Could you get it?
I can get it.
Your Honor, I just realized she doesn't, it's financial responsibilities marked no on this, and I hadn't discussed with her bringing in proof of financial responsibility for today. So if we do this today, could you get that and get it to the court by 4 o'clock today?
That's going to be tough on 20.
Yeah, probably.
I assumed it would be. I
Probably
just didn't
not.
want to absolutely say not.
Yeah.
Then I think we probably need to continue this one more time, Your Honor. I apologize.
No, that's okay. We'll come back July 8th at 10 a.m. for sentencing.
Thank you, Your Honor.
Thank you.
Yes, you need proof of insurance that day.
Okay.
So you know what day it is? Here, let's step outside. No.
October.
Let's step outside.
State of Ohio versus Nicholas R. Adams, case number TRD 2014-80.
The state of Ohio versus Nicholas R. Adams, case 2014-80. Mr. Adams is present. You're unrepresented by counsel, correct?
Excuse me, sir?
You don't have counsel?
No,
correct?
sir.
Okay. And Mr. Hill is represented in the state of Ohio. It looks like this was a, sentencing. Looks like you've got 12 hours of community service left and you owe $435. This is a 2020 case. Looks like you failed to appear several times in the past. Mr. Hill? Your thoughts on this? There was nothing's been done yet on it. Sir, are you in treatment anywhere?
I do IOP in Kentucky. I'm here, I've been paying on a fine. That's what I come every month and show that.
Your Honor, no matter where it's a sentencing folder, it may not be updated.
Yes, sir.
You're correct. Okay, yeah, I see. You made last payment on May 14th.
Yes, sir.
Yeah, it's definitely.
It should be about a month.
Okay, looks like you only have $180 left. So-
And I was gonna make a payment today also.
Okay, how much you gonna pay?
30.
30?
Yes, sir.
Okay.
And I don't believe I have proof of the 12 hours of community service. He probably will have to do that.
Yes, sir. Yes, sir.
Okay. All right, we'll come back July 8th at 10 a.m. for sentencing.
State of Ohio recalls Eddie Easton,
Can I-
case number CRB 23203, TRC 21269, TRC 17442, A, B, and C. Eddie Easton.
So the state of Ohio versus Eddie Eastep, CRB 23203, TRC 21269, TRC 17442. This matter was set as a review this morning. All right, Mr. Eastep, on one case, you still owe $175. Looks like you still owe a fair amount of fines. Are you working, Mr. Eastep?
Yeah,
Where you work?
people ready.
What days do you work?
Monday through Saturday.
Your Honor, he was at community service
Yeah.
last Thursday.
Yeah.
I believe it was last Thursday, and it went towards fines, I believe.
Okay. Yeah, I don't see that he owes any community service left, so it's just working on fines. All right, Mr. Eastep, I'm going to set you another hearing. Let's do July 22nd.
Thanks, sir.
Thank you. That'll be at 9, back at 9 a.m.
All right.
We're going to take evidence now. You're going to get to jail.
State of Ohio versus Donald L. Denning, the second case number CRA 24335. I'll call the jail. Let them know.
Mr. Morford, this is going to be your case for preliminary hearing once the jail gets on. We're still waiting for Mr. Stratton, who is apparently on trial.
Oh, yeah, I'm gonna end up putting that here.
I set it up there so.
Oh, I see. No, well, you can move it, I guess. We can put it under here. Doesn't matter. It's a whole new era. It's a whole new era. Thank you. Might be a police.
You got to get out the electric over here,
Oh, there's a plug right, there's a receptacle right there.
but they got to run to it.
Well, I figured for the time being, I can just run a cord over there.
You trying to trick me?
Yes. You're agile. You ready? I always think about the day that we had the group of people that went to Lowe's and we tried to open the accounts and all that, how funny that preliminary hearing was.
Never happened again. I didn't know about the FBI picked them up.
Did they?
Civil Service. I'm glad that somebody's doing something. All this stuff that's going on makes you think that they're not doing anything. I got a friend that's retired. I call him. I got a funny friend that's interested. Well, but I found one. Oh, so you actually found one and taken it? Well, evidently, the drug task force out of South County is headed up by the Department of Justice. Well, they got to do Jim Estrada is the guy's name. And once I got a hold of him, he said, I'm familiar with your guys, with Landon and all that. He said, we'll set something up, but shouldn't we do it? Oh, Denny, yes, sir. Well, here's the thing. He's got an APA holder too. And so he's not getting out.
Yeah, sorry. Kentucky has them for 8 days. She said.
I don't care if we have, it's an easy preliminary to have. You can copy the file as far as I'm concerned.
All right, this is State of Ohio versus Donald L. Denny II. Mr. Denny is on the Zoom. Can you hear me, sir?
He's muted.
I think you're on mute.
Now?
I can hear you now. Can you hear me?
Yes, sir.
All right. Mr. Denny's present on Zoom and his attorney, Warren Morford, is present on his behalf here in court. State's represented by attorney Philip Healy. This matter is set for a preliminary hearing this morning, and we're about to take some evidence. So, Mr. Denny, you're going to be present listening unless Mr. Morford calls you. And so we're going to start taking testimony. So I'll need you. Well, one more. I'm going to mute you on our end, and then Mr. Morford will have an opportunity to speak with you as well if he decides that he's going to call you. So I'm going to put you on mute here. Not if you can still hear me. Okay. All right, Mr. Hill.
We would waive an opening.
Likewise.
Okay, so waived.
Deputy Mullins.
Deputy Mullins, you want to come on up? Raise your right hand. Swear affirm the testimony you're about to give will be the truth, the whole truth, nothing but the truth.
I do.
Okay. Mr. Hill.
Thank you, Your Honor. Sir, are you Deputy Jeff Mullins of the Lawrence County Sheriff's Office?
Yes, sir, I am.
Were you employed there on June the 1st, 2024, and were you on duty, and at that time did you have dealings with Donald L. Denny II?
Yes, sir.
And he is on the screen. Well, do you see him on the screen up
Yes,
there?
sir.
And if that's him, could you point
Yes,
to
sir.
him, please?
That'd be correct.
Were you dispatched to 49 Private Drive, 1693 in South Point, Ohio at about 6:49 in the evening on June 1st?
Yes, sir, I was.
What was the reason that you were dispatched there?
Dispatch had received a call that a resident of a treatment facility had assaulted two other residents at that location.
and then after the incident had fled on foot from the facility.
Who were the two people that were allegedly assaulted?
That was Brendan Rude and Michael Haar.
Did you make contact with them?
Yes, when I arrived, I made contact with Mr. Rude and Mr. Haar. Lawrence County MS had been dispatched there to check both of those individuals for injuries. And I spoke to both of them when they were in the back of the ambulance and took written statements from both of them.
As to Mr. Haar, do you know what the injuries were that he sustained?
At the time of the incident, he stated he'd been struck in the left side of the face in the upper cheek temple area.
Have you learned of the extent of that injury?
Yes, sir. I returned the next day on June the 2nd to drop off copies of the victim rights packets to both individuals, Mr. Rude and Mr. Harm. It was at that time I asked them what injuries they'd suffered. Mr. Har had made mention that he had a fractured orbital socket on the left side of his head and that he was being referred to a surgeon for that.
Was there a discussion about the potential of losing his eyesight?
At that time, he did not.
I'm going to object, Your Honor. You're saying it's not relevant.
Sustained.
Did you learn of a further diagnosis concerning his eye?
No, sir. And the only thing he mentioned that he had been referred to a surgeon for a fractured orbital socket on the left side of his head.
I'm going to object and hearsay, Judge. Again.
Mr. Gill.
Well, this is a preliminary hearing. I don't know that the strictness of the hearsay laws, rules apply as they would in a contested hearing of proof beyond a reasonable doubt. This is just a probable cause hearing.
Whatever will be objection.
Did Mr. Har tell you how this incident happened?
As a result of the alleged assault by Mr. Denny.
And it happened at this address, at this facility?
Yes, sir, that would be correct.
Now, also, Mr. Rude, did you talk to him?
Yes, sir, I did.
What did you find out happened with respect to Mr. Rude?
Mr. Rude, in his written statement to me, advised that he was on the telephone speaking with a female and that he felt a punch in the back of his head. And when he was knocked to the ground, he observed Mr. Denny punching and kicking him until someone intervened, who I later found out was another resident, Paul Bridges.
With respect to Mr. Denny, did you determine that his injuries were such that he had sustained serious physical harm?
Mr. Denny or Mr. Har?
I'm sorry, Mr. Har.
Okay. After the fact, this is the next day, when I spoke to him, both individuals, I can add that please the court, both gentlemen were transported to St. Mary's Hospital in West Virginia to seek treatment by ambulance.
That's all I have, Your Honor.
Mr. Warford, cross-examination.
At the police court, counsel, Deputy Mullins, could you tell me if you thought my client to be under the influence of drugs or alcohol at the time of this incident?
I didn't get an indication of that, no. I can tell you, Mr. Morford, he did walk back to the facility after the fact and was compliant when I took him into custody and provided me with his identification.
Did you transport him to jail?
Yes, sir, I did.
Did you notice any physical injuries to either one of these gentlemen, Mr. Rude or Mr. Hart?
Mr. Rude had dried blood around his mouth. He had a large knot on the back of his head, and at the time it looked like a pinkish type injury to the left side of his rib cage.
He's the one
He was
that
the younger gentleman of the two.
was hit in the back of the head?
Yes, sir.
On the top, okay.
Yeah.
I didn't mean to interrupt.
That's okay. Evidently, from what I'm understanding, Mr. Morford, there was 2 assaults that took place at different times. The initial assault was Mr. Rube alleged that Mr. Denny had assaulted him, and Mr. Bridges had intervened.
During the course of your investigation, did you determine what set this off? Why?
No, sir, there wasn't any discussion. According to Mr. Rude, he was on the telephone speaking with a female friend of his, and this just happened out of nowhere.
Okay, and you say these were 2 separate?
That's correct.
And how far apart in time were they separated? Can you tell?
I'm assuming a very brief period of time, the way it was related to me. I mean, they didn't give me minutes or any indication of an exact time frame. I don't know if that answers your question or not, but yeah, I mean, it was a short time frame.
I just want to see if it was close, the same day or different days.
No, sir. This was all, like I said, within probably, if I had to guess, approximately a 15, 20-minute period. I wouldn't think it'd be much more than that.
And I believe you said that you took written statements from Brandon Rude and Mr. Hart?
That is correct, in addition to the witness, Paul Bridges as well.
Paul
Bridges, he's also a resident of the facility.
Where are those written statements?
They should be attached to the my written report that the prosecution should have.
Okay. With respect to Mr. Denny, did you observe any injuries on him, or did he complain?
He did not. In fact, Mr. Morford, I really didn't have much interaction with your client, other than to ask for his identification and to gather his property when I took him into custody. And in fact, as we started from jail in the back of the car, he just randomly had mentioned, he said, "No disrespect, sir, but I don't want to speak to you." I respected that. I would assume that that was him invoking his
That's his right, isn't it?
That's correct.
That's all I have, Your Honor.
Mr. Gill, any redirect?
You mentioned the person that sounded to me like a witness, Mr.
Bridges?
Bridges?
Yes, sir.
So he saw both assaults?
Mr. Bridges had stated to me that he observed Mr. Denny on top of Mr. Rude punching and kicking him, and he walked over and pulled Mr. Denny off of Mr. Rude. He had also mentioned that he was on the staircase inside the facility with Mr. Har when Mr. Denny walked by and struck Mr. Har in the side of the head. So yes, sir, he did.
Thank you. That's all I have, Your Honor.
Okay. Mr. Morford?
Nothing further, Your Honor.
All right. Deputy Mullinger, you can step down.
Thank you, Your Honor.
Mr. Gill, any other witnesses?
No other witnesses, Your Honor.
All right. Mr. Morford, do you wish to call any witnesses?
I do not. Thank you, Judge.
All right, based upon the evidence presented and the testimony that I've heard here today, I'm going to find that there is probable cause, and so this matter will be bound over, these matters, both matters will be bound over to the Lawrence County Grand Jury.
Thank you, Your Honor.
Thank you.
Do you want to set a date? I believe you've still got a misdemeanor. Are you going to take that down, Mr. Heald, or?
We'll molly that to the grand jury.
Okay. The CRB 24336 will be nollied to the grand jury. And I'll find probable cause on the CRA 24335 and be bound over the grand jury.
Thank you, Your Honor.
He's the CPS still staying with that?
Yes.
Okay.
I mean,
I just missed one person on the protection.
Thank you, Mr. Morford.
Thank you, Your Honor. Go have a good day.
We're finished at the jail.
I'll just have to do it.
We're going to be in recess until, we don't have anything else to do. Other than
Just
Stratton. We'll be in recess till 12:30. Mr. Stratton is in a trial and is supposed to be available at 12:30. Court's in recess.
Okay,
Fun yet?
just started. We stopped.
When it's done, you just start having fun.